Let's take a look at medical information. Employers, even those that do not self insure or administer their own health plans, amass a considerable amount of medical information on their employees. The Americans with Disability Act places limits on the type of medical information that can be obtained from employees. After employment begins, medical information can be gathered only to the extent that is job related and necessary. The ADA requires employers to keep information obtained on an employee medical exam or inquiry in a location apart from other personnel records and treat it as confidential medical information. The OSHA provides employees and unions with the right to access medical and exposure records created in compliance with the Act. A number of Occupational Safety and Health Administration standards require medical monitoring of individual employees, as well as monitoring of the workplace for levels of exposure to toxic substance and harmful physical agents. Because occupational diseases can take a long time to develop, exposure records must be maintained for 30 years, and medical records for the duration of employment plus 30 years. Medical records of short-term employees, less than 1 year, need not be retained as long as they are provided to those employees upon termination of employment. Unions and health professionals need the specific written consent of employees to have access to their personal medical records, but they can examine exposure records without obtaining consent. Medical privacy regulations under the Health Insurance Portability and Accountability (HIPAA) are also relevant. These regulations primarily affect healthcare providers and self-insured companies. However, any employer that receives protected health information from insurers or healthcare providers has obligation under the law. Parties with access to protected health information must limit the uses and disclosure of that information, train staff on maintaining the privacy of medical information, and notify employees of their rights. Employers have the right to inspect and copy their medical records and propose corrections. However, the regulations do not require that consent be obtained before using or disclosing information in employees' medical records. Additionally, HIPAA regulations apply only to medical information derived from the administration of group health plans. Other sources of medical information are not affected. The HIPAA medical privacy regulations further underscore the need to handle medical information in an especially careful, confidential manner.